Good morning.
Good morning.
I have a moment to sip a little water before my clock starts.
I want you to help yourself.
Thank you. At the outset, let me request that I be able to reserve 2 minutes for rebuttal if I could.
You may. Thank you.
Good morning, honorable judges of the Court of Appeals of East Tennessee. My name is Gerald Tidwell. I'm a member of the Hamilton.
East Tennessee, of Tennessee, the state of Tennessee.
I'm sorry, Judge.
We're sitting in the east, but we are of the state.
I see, Your Honor. I'm a member of the Hamilton County Bar and have been for 42 years. I represent Kendall Walls, one of the children of George Walls, his only daughter, and she's also the executor of the estate. This is a matter involving the construction of a will. George Walls died in August of 2018. In February of 2011, he created a will. And this is probably one of the most difficult, if not the most difficult wills I've ever seen to interpret. He did it himself. It's homemade. It's rather confusing in some areas. And I say that to say that I have great respect for Chancellor Atherton, having appeared in front of him many times, tried cases with him as a lawyer. I don't envy anyone trying to interpret this will, but I disagree respectfully with his decision. This will contains 20 paragraphs. Most of them deal with the attempt to create a trust for real estate, the real estate at issue here, and how to handle that real estate in a trust. The assets consist of a small, poorly kept house in Florida on Magnolia Road, which is what I refer to it as. This is the subject of a probate matter in Florida. It's about 720 square feet. A piece of unimproved real estate in Marion County, Tennessee, I call South Pittsburgh, of limited value, which was literally covered with abandoned vehicles, motorcycles, vans, conveyances, trailers, boats, etc. It had some value. But the crown jewel of the property in the estate is a commercial property in downtown Chattanooga near the aquarium on Market Street, which I call Market Street. It is currently rented to Republic Parking as a parking lot and generates somewhere around $6,000 a month. When we subpoenaed the records several years ago from George Wall's death in 2018 to September of 2023, $338,000 in rentals had been paid to Kenneth Walls, the son of George Walls, as trustee. The first issue we're raising before the court is the decision of the trial court to essentially distribute this real estate through paragraphs A5 and A6 of the will. We do not believe they show a donative intent, and we do not believe they are appropriate for distribution of this property. The cardinal rule of will construction is to ascertain and give effect to the intention of the testator, and that is the bulk of our argument. The law in this state is very clear that every will has to be construed by itself and stands on its own facts. In applying that rule, it's necessary for the courts to look at the whole will and to ascertain from the particular words used, from the context, and from the general scope and purpose, the purpose of the will. It must be read in light of the facts that existed at the time it was created. The most important provision of law that I think applies to this case is that if a portion of a will is found to be invalid, that does not mean you don't consider it in finding the intent of the testator. Here, the trust he attempted to create failed for lack of beneficiaries, but there are many provisions in it that deal with the trust that show what we think is his true donative intent. We would ask this court to read this will, this layperson's will, and give effect to each and every word in it. A5 and A6 don't make absolute gifts of real estate. The will's controlling theme is to hold real estate in trust. That was his intention, not to favor one child, Kenneth, over his daughter, Kendall, who arguably has been left, at least it would appear, an attempt to leave the Florida house to her. Everything else is cut off from her. That is not what we think was his intention. We disagree with the trial court's decision also because it takes one sentence in paragraph A6, and I'm going to refer to him specifically in a minute, and basically abrogates the rest of the will with that one sentence. That is the opposite of harmonization of the wording of the will that we're supposed to do as we try to interpret a layperson's will, as well as any will drawn by a lawyer. regarding the trust that failed, it's important to note that this property on Market Street was deeded to George Kenneth Walls as trustee of his own trust in 1972 when I was in high school in Chattanooga, and it remains deeded that way today. George Kenneth Walls, the deceased, filed a lawsuit in March of 2017 in the name of him as trustee. When he died, his son Kenneth, the proponent of the decision of the trial court, also stepped in as plaintiff as trustee. The suit was settled for $100,000. It was paid to the trustee, Kenneth Walls, and he received it. It is clear from the facts that George Walls seemed to think he had a trust and operated as if he had a trust, and when he wrote his will in 2011, he must have clearly thought he had created a trust for real estate. Those provisions are A14 and A20, and it says, the assets of real property and other tangible assets will be held in trust. And it goes on to refer to other items.
Excuse me, counsel,
Yes,
for
sir.
interrupting. Was there a written trust document?
We could not find one. There were some notes written on, I think, an envelope or some paper, but I would not say they're a trust, Your Honor.
It was not attached to the will
No, sir, it was not.
or any codicils?
No, sir. A20, the next paragraph I want to refer to, also refers to there being one trust is to be maintained for real property and others for CDs and other assets. You will only find the term real property in these two provisions. The provisions Chancellor Atherton found to have donative intent don't refer to real property, they refer to property. To refer to those provisions, and I'm going to pull the actual will out, A5 says, my daughter, Kendall W. Brown, is to receive any property and furnishings at 3 Magnolia Lane in Florida. A6 says, my son, G.K. Walls, is to receive all other properties and all other items and furnishings, as well as items that are contained in the utility buildings at various places. And then it says, a second sentence, which is very important, he should distribute or liquidate these items as suggested by joint decision of the executors or trustees. Of course, Kendall Walls is the only executor. The reason this is important is I don't think these convey anything. I don't even think they convey personal property. I think they're instructions pursuant to a trust that he thought was created or he had created as to how to handle it. If you look at the terms, it's to receive. To receive is defined by Webster's Dictionary as to come into possession of. It doesn't necessarily mean ownership. That language is contrary to the other attempts at conveying property, where he, for example, in one paragraph, he says, I may devise and bequeath. And then he says later, I devise and bequeath. He uses other terminology. He doesn't say to receive. That is not dispositive language. Secondly, in paragraph A6, we have this to receive all other properties. Other properties, I think, is referring to the items, furnishings, and other things listed below, which would be personal in nature. But then it's limited by the last sentence, and it puts a limitation or restriction on him that he has to check with the executor and talk about whether to distribute and liquidate and who to give them to, is the way I read that. That is not donative intent. It's certainly not a residuary clause, as the court found. I would submit to the court very respectfully. A7, then right after A6, the clause is supposed to dispose of everything, A7 says it gives detailed instructions on how to handle all these dozens of cars and vehicles he had. Why would he do that in A7 if he thought he'd disposed of the property in A6? It doesn't make sense to me, at least. I think A5 and A6 don't devise anything. At most, they may devise personal property. They certainly don't devise real property. But the reason I think they don't devise anything is because the overriding scheme of the will is to create a trust for this real estate, which is the only real value that he has. If that's the case, it either has to pass through a residuary clause or through intestate succession. As to the residuary clause, Chancellor Atherton found that A6, the one I just read at some length, is both a bequest and a residuary clause. However, A2 says, and I read it specifically, I devise and bequest the rest and residue of all my worldly goods to be distributed by my executor in an equitable manner among my issue and bloodline. That is the clearest, easiest to read and understand paragraph in this will, I think, except for A20 that says there's to be one trust maintained for real estate, and then A14 that says the assets of real estate and other tangible assets I wish to be held in trust. That's the clearest terms I've found in the will. If there is a residuary clause in this will, it's got to be A2, I submit respectfully. The terms devise and bequest, that's the only place he uses that. The rest and residue, these are clearly lawyers' terms. I don't know where he found them. He was an engineer, a man of education, but he found lawyers' terms, and that's what he put in here. And he wants to leave it to his issue or bloodlines. He only has 2 issues, Kenneth Walls and Kendall Brown. This language would indicate that if there is a residuary clause, that's it. And as to the term worldly goods, you can look that up in the dictionary too. It does include real estate, or it can, as well as personal property. It's a generic term. Is it the best term? No, it's not the best term. But if there is no residuary clause, and I submit A6 is not attempting to dispose of residuary, then it's A2. If it's not that, it would have to go by intestate succession. As to the other 2 issues briefly that I raised, we asked that this court determine whether or not the executor is entitled to fees on appeal. We do that out of an abundance of caution. I've been on the receiving end of failing to do that, and I don't want to do that again. We're simply asking this court decide whether or not she's entitled to fees and direct how those would be determined. As to the 4th issue, there is a stay on enforcement of the court's order, which directs that the South Pittsburgh vacant property and Market Street property in Chattanooga that's quite valuable be conveyed to Kenneth Walls as a part of the decision. We simply ask, if you rule against us, that not be done immediately in your mandate. State that, because we still have an issue of whether or not this is an insolvent estate and whether or not real estate needs to be brought in to pay the expenses. And we also have pending motions involving trial level legal fees. I still have a little bit of time left. Could I answer any questions?
I hear none. Thank you.
Okay. I'll defer to my esteemed colleague, Mr. Horton, and then use my 2 minutes for rebuttal if I need. Thank you very much.
Thank you, Mr. Tidwell.
Bill Horton from Chattanooga. I represent George Kenneth Walls, the son of the decedent. The decedent had 2 children.
Yes, sir.
The way this issue came before the probate court was that Mrs. Brown, the daughter, probated the will in Florida where Mr. Walls was living. That's the property she was bequeathed in the will. So she not only probated the will in Florida, but she transferred the title to that property to herself by executor's deed. Then she filed an ancillary probate in Chattanooga in 2020 because the 2 real estate properties were in Chattanooga. I guess the court will remember Classic Cars on Market Street. That's what Mr. Walls operated. Then it became a cheeseburger place. And then the building collapsed, and that's when the litigation started over that property. So the way this issue really came before the court was simply Mr. Walls asked Ms. Brown, the executor, to go ahead and execute a quitclaim executor's deed to those properties. And she had not taken any position on that property and done anything for 3 years. She asked for instruction of the court. The court had a hearing. So really the issue before the court was interpretation of the will in connection with those 2 real estate properties. This will was done in 2011. I don't think what the circumstances were in 2024 make much difference on interpretation of the will that was drafted in 2011. The court did find that this will was challenging. But there's some principles the court had to utilize in constructing the will. First, the court applied the principle that when a layman does a will, even an engineer, he was organized, he had all of his paragraphs numbered. He did mention about everything he owned in there, including Bibles, books, cars, boats, book collection he had. So obviously the first principle is that it's presumed that a person who does a will intends to dispose of all of his property. There's a presumption against partial intestacy. The second principle the court used is that there should be some liberality in construction when a layman is doing his own will. And I mentioned the presumption that the testator intended to dispose of all of his property. It's confusing to me what Mr. Tidwell's tried to argue. And at first, he tried to argue the entire will should be abrogated because it's an interpretation issue. I don't think that's the law, that you convert the entire estate into an intestate estate. I think what this case boils down to is she wants to keep the property in Florida that she got, and she wants to declare the other real property as intestate property so she can claim half of it. That's basically what is at stake here. Now, it certainly was not the intent of the testator, Mr. Walls. In fact, there's some testimony that he intended that property to go to his son because his son had been involved in his property for years, helped him operate it. It became a parking lot after the building collapsed. He operated the parking lot. He paid all the litigation, the lawsuit. He was even named a party to the lawsuit, George K. Walls, when his dad died because of the will. The executor was never a party. She never took any position in litigation. She never asserted any rights or claims to the rent. So those are factors the court considered. Also, there's some testimony that she had received a house from her mother and that she owed her father some debt, and that's why the father wanted the son to have this other real estate. There was also testimony before the court on that. I think the confusing part, and the court probably wrestled with this a little bit, was this idea of the intention of a trust. The court, I think, correctly ruled that it did not meet the requirements of a Tennessee code on a testamentary trust. There's no details on how the trust will be administered, who the real beneficiaries were, distribution scheme, the term of the trust, the length of a trust. There's some references. I think what he was really trying to say is evidenced in paragraph 8A, because he held this title to this property, Market Street, and his name is trustee, and he explained he did that to protect himself from creditors. It was a dry trust. In other words, he owned that property for himself as trustee. That's why it was considered an asset of the estate. But if you read A8, he said, "It is my desire that my children should manage their finances so that no proceeds of its holding should fall into the ownership of any entity or persons who is not of my issue or blood." This engineer had in his mind that he wanted the kids to protect their own assets the way he had tried to protect his assets. A14, he says, "The assets of real property and other tangible assets I wish to be held in trust for investments." Chancellor correctly ruled that was just a wish. That was not a directive. He's conveying a wish to the beneficiaries that you should hold your property in some kind of trust to protect your property. As Mr. Tidwell admitted, no trust was ever found of any kind that dealt with these properties. Another issue, or a couple issues raised, and also we go back to the principle that there's a presumption, strong presumption against intestacy. If he's asked this court to rule that she keep her property and the will disposes of personal property, but you carve out these two real estate properties in Chattanooga and South Pittsburgh and treat them as intestate property, and the will controls everything else, that's called partial intestacy, and there's a strong presumption against that under Tennessee law, and I cited the cases on that. It's presumed that a testator intended to dispose of all of his property. So that would go contrary to the concept of law. On the attorney fees issue that he mentioned, obviously she's asserting all of her attorney fees should be a debt of the estate and should be paid, and primarily her attorney fees in fighting with her brother over the interpretation. Court already referred that to the clerk and master, and on remand, that's an issue for the clerk and master to resolve. If you don't have enough personal property and estate to pay all the debts, including attorney fees, you can drag real estate back into it to pay those debts. But here, the primary debt is attorney fees and fighting over interpretation. So that's an issue that should be reserved to the clerk and master and the trial court on remand.
So, excuse me for interrupting, counsel.
Yes, sir.
So the issue of any insolvency has not been addressed yet. The trial court has not made a determination as to whether the estate is insolvent.
No, that was referred to the clerk and master doing accounting. Clerk and master has not finished that yet. And this was declared as a final order, so this issue could be put to rest before the clerk and master and the trial court decide that issue. Also, I wanted to point out one other issue here, and that is, we're going back to this trust idea, is the code section on dealing with the trust, and the court cited this as 35-15-402. The court said that this does not constitute a testamentary trust. There's no testamentary trust in the will. There's no trust attached to the will. There's no trust that was found as an inter vivos trust that was incorporated by reference. So the court is correct on that interpretation. One other final matter is that there is a code section in Tennessee that does apply to the presumption that you intend to dispose of all your property, both real and personal, when you do a will, and that's TCA 32-3101. It has to clearly appear from the instrument in the four corners of the will that the testator intended to carve out assets. That has to be clearly the intent as expressed by the instrument. There is no such clear intention on that. One other issue that I'll sit down is that the interpretation of A6. G.K. Walls is to receive all other properties. The court correctly construed that to include both real and personal properties. In case law, I cited on that the reference to all other properties do involve both real estate and personal property. Mr. Tidwell cited a case in here arguing against that, but in that case, a Kowalski case that he cited, the residuary clause said all monies. It didn't say all other properties. So that's why the court in that case did, in fact, find that there was not treatment of a certain other piece of property. So you do have that presumption, and I don't understand the comment that my esteemed colleague made about A6, about the joint decision of Brown's trustee. What I was talking about was the items in utility buildings in Florida. That's what he referenced. There's a utility building in Florida at the property I'm giving to my daughter. I want them, as to those items, to jointly decide what to do to those items in the utility building. That's what he was referring to in there, not to the real estate itself. So the bottom line is, she probated this will and devised the property to her, conveyed to her, and when it came time to perform her duties under the will and convey the property to her brother, she protested 3 years later. So I feel like the court made the correct decision here interpreting a difficult will, but the principles he applied should have been applied, and I think his interpretation is correct.
Thank you, Mr. Harden. Mr. Tidwell?
Thank you. Let me first mention that my client, Mr. Horton and I came to this case years after it was open. When I came into the case, literally, and you can see in the record if you look at the pleadings, almost nothing had been done, except Kendall Walls was advised by Florida counsel, which she testified to on the record, to deed that property to herself. She was not trying to make an election and walk away from everything else. She simply was trying to do what the lawyer in Florida said, under Florida law, I assume. However, she's made it clear in the pleading, in the brief we filed, as well as pleadings in court, she'll happily roll that house back into the estate. She'll happily take an offset for the value of it against anything she gets. She's not trying to double dip. It's a 700 square foot cinder block house, not on the beach. It was full of junk. It didn't even have utilities hooked up to it. It was not livable when she went down there. She's physically cleaned it up and put her own money into fixing it up, thinking it was hers at one time. That is not an election, I would submit, if that's what Mr. Horton is referring to. She did not attempt to act in a way inconsistent with what she's doing now. She just simply lacked the advice I think that she needed. As to the other items mentioned, a presumption does exist. It's not a prohibition against finding intestacy. When you look through this will item by item, you may see why I say that. The information Mr. Horton referred to about testimony, I think it's important to know that Chancellor Atherton, look at his order, he never told us if he considered extrinsic or parole evidence or what he considered. It's not clear. There was evidence offered under objection on both sides. I don't know that that even comes in or is relevant. What I'm asking this court to do is reverse the trial court, find that A5 and A6 are not dispositive of real estate, either in Tennessee or Florida, and either find A2 as a residuary clause to allow its provision to go into effect, or declare it the estate intestate as it relates to the real estate, specifically Tennessee's real estate, but if the court so chooses. And I'm not sure the court has the power to say that about Florida. But again, she has pled and is willing to wrap that property back into the estate to avoid any appearance that she's trying to double dip. Thank you so much for this opportunity. Thank you for your
Thank you, Mr. Tidwell and Mr. Horton, for your presentation. Your case now has been submitted to this court for resolution. You should receive our opinion and ruling within a reasonable period of time. Thank you very much, and you may be excused. Mr. Clerk, will you recess court until this afternoon, please?
All rise.